Hey everybody, brand new week and welcome into our latest TDR Cannabis in 5 presented by Dutchie. I am your host, Shad Dales. We got an interesting story that developed late last week out of Florida where a court just ruled that police can't automatically search a vehicle solely based on the smell of marijuana. This is interesting. That might sound like a small tweak, but in practice, it changes how law enforcement interacts with cannabis in a place where medical use and hemp are already legal. So today we're going to break down what the court said, why it matters, and what it could mean for cannabis law across the country as we look into the future from a law enforcement perspective and how this industry could look for years to come. So let's get into our latest TDR Cannabis in 5 presented by Dutchie. All right, here's the key. Florida's 2nd District Court of Appeal overturned the long-standing plain smell doctrine. In the case of Darrielle Ortiz Williams, a police pulled over a vehicle, claimed they smelled marijuana, ordered everyone out and searched it, and they found, what else? Cannabis and pills. But the court ruled that smell alone is no longer enough to justify a search. Because laws have changed, hemp is legal, medical cannabis is legal, the odor of marijuana can't automatically equal probable cause. So wow, these words were clear. Quote, mere odor can no longer establish that it is immediately apparent that the substance is contraband, end quote. So when you look at that, it's a big reversal of precedent, and the judges even asked Florida Supreme Court then to weigh in, signaling how important this issue really is. So now that that's happened, you may ask why this matters so much. Well, first, for people in Florida, this ruling is a real shift. Vehicle searches based only on odor were common, and they have been common a lot. But now police are going to need more evidence. Visible contraband, erratic driving, suspicious behavior, smell alone isn't enough. And second, it reflects the reality of legalization. If hemp and medical cannabis are legal, then smell doesn't automatically equal criminality. So here's key. Courts are starting to recognize that. And third, it actually could inspire challenges in other states. Florida isn't the first state to roll this back, and let's face it won't be the last. And finally, this is about civil rights. Smell is subjective. Too often, it's been used as a pretext to target certain groups unfairly. So this ruling really reins that in. And speaking of protecting people's rights, here's a message from our good friends over at Morgan & Morgan. Hey everyone, there's a reason smart investors celebrate when their portfolio jumps 40% in a year, just like there's a reason Morgan & Morgan is America's largest injury law firm. Think about it. When you're investing, you want the right team in your corner. The same is true if you're injured in dealing with an insurance company. And that is where Morgan & Morgan comes into the equation. Why? Well, they've got more than 1,000 attorneys in over 100 offices nationwide, and they've been fighting for people for over 35 years. And their track record is hard to ignore. Let me explain a little bit further. Case in point, in Florida, a client was offered $350,000, but walked away with $12 million. In Pennsylvania, another client, they turned $650,000 offer into $26 million. That's a 40x return. Another in Pennsylvania, where a client got $29 million after the insurer only offered $500,000. And in Florida, someone received $20 million when the last offer on the table was literally zero. Think about that. So in total, Morgan & Morgan, they've recovered more than $25 billion for over 500,000 clients. That's like compounding wins in your portfolio every single year. So really, when you hire him, it's like bringing in a legal army that has your back. Because if you're injured due to someone else's negligence, you deserve to be paid. And let's be honest, not all law firms are created equal. Choosing the wrong one can cost you, just like choosing the wrong stock. But with Morgan & Morgan, their fee is free unless they win. You can start your claim right now by clicking the link in the description below or by scanning this QR code on your screen with your phone. At the end of the day, if you want what you deserve, make sure you go in with the right team by contacting Morgan & Morgan today. Now, let's get back to the rest of our video. All right, let's now zoom out and compare Florida's decision to what's happening in actual other states right now. When we look at this, Florida is joining a trend what we're seeing nationwide. One, in Minnesota, the Supreme Court said police can't rely solely on smell to search vehicles. Over in Maryland, lawmakers are barred from odor-only searches even before full legalization. And in New York, reform advocates successfully fought back against proposals that would have lead odor trigger impairment testing. So the common thread here, odor is no longer a reliable signal. You got hemp, CBD, and cannabis products, they can all smell the same. But, like I said, not all are illegal. So this is actually a ripple effect on cannabis reform. It doesn't change what's legal, it reshapes the enforcement enforcement tools that police rely on right now. So practically, what does this now mean on the ground within the state of Florida? Well, one, police officers will now need to stack more indicators before initiating a vehicle search. Expect them then to lean more on visible contraband like paraphernalia or open containers. Also behaviors such as nervousness or evasive answers. Then you have actual context, which is impaired or reckless driving. So for drivers and medical cannabis patients, this reduces the risk of arbitrary searches. For law enforcement, it creates obviously new training challenges. So some are already pushing back, saying it could limit their ability to catch traffickers or impaired drivers. So that tension, it's between civil rights and policing, is exactly why this debate will keep playing out in courts and legislatures. And let's face it, this is a conversation that's not going away anytime soon. Fair points on both ends of the spectrum right now. So saying all this, here's my takeaway. One, this is more than technicality. It's a recognition that cannabis laws have evolved and legal doctrines must evolve with them. Two, it puts pressure on police to adapt. They can't just rely on smell anymore. They need stronger evidence. And number three, it highlights how reform doesn't just happen through legalization votes or Congress. It happens through courtrooms, through rulings like this one. So really, if I'm being blunt, this matters because it chips away at outdated drug war practices. Every time a state or a court updates these doctrines, it moves cannabis policy closer to fairness and consistency. Again, something that we've been talking and advocating for a long time. So there's your latest TDR Cannabis in 5 update, where Florida just said smell alone isn't enough for a vehicle search. It's a big shift for drivers, a challenge for police, and let's face it, it's part of a broader trend we're seeing across the country. So we'll keep watching how Florida's Supreme Court responds and whether other states are indeed going to follow this. That's our latest TDR Cannabis in 5 presented by Dutchie. I'm your host, Shad Dales. Don't forget to like, subscribe, and smash on that bell for all notifications. And also leave your comments below and let us know what you think. Is this the right ruling? Is this protecting civil rights, your rights? Let us know and let's keep this conversation going. Until next time, enjoy the rest of your day, and we'll see you all in the next video. I'm your host, Shad Dales. This is the latest TDR Cannabis in 5 presented by Dutchie. Thanks again.